I'm going to turn it over now to Melissa Martin. Mel is a Florida attorney currently living in Oregon. She has been active in clean water advocacy and conservation, including working to defeat a pro-fracking bill in Florida and leading a countywide coalition that instituted a sales tax to support restoration projects for the Indian River Lagoon. Mel was an adjunct professor of law teaching water pollution law and environmental ethics at Barry University School of Law, which is also her legal alma mater. Mel?
Thank you very much, Dan. Let me start the presentation. Hi again. My name is Melissa Martin, and my section will be covering the latest advances of international rights of nature, lawmaking, and test cases in other sovereign nations across the globe, specifically the countries of Ecuador, India, Colombia, and Bangladesh, with honorable mention of a few others. So let's begin with the main feature of this doctrinal movement, the country of Ecuador, which again is the first country to incorporate rights of nature provisions into their national constitution. So about 14 years ago, Ecuador established a constituent assembly to transform the institutional framework of the state and write a new constitution, a move that was passed with over 80% approval. So it seems that they were in support of and ready for some fundamental changes in Ecuador. The new constitution was ratified by referendum in September of 2008 and was the first in the world to recognize legally enforceable rights of nature. And there are four main provisions, Articles 71 through 74, that make up Chapter 7 of the Constitution, entitled Rights of Nature. So we're just going to step right through them. The first of the four is Article 71. The recognition of the rights of nature in the Constitution is stated in Article 1 that explains nature, or Pachamama, as the bearer and maker of life that has the right for its existence to be respected and preserved, and its vital cycles, structure, features, and evolutionary processes to be regenerated. Now, there are other points within Article 71 that I'll come back to in a little bit because they're about standing and procedural issues. Article 72 states nature has the right to be restored. This restoration shall be apart from the obligation of the state and natural persons or legal entities to compensate individuals and communities that depend on affected natural systems. In those cases of severe or permanent environmental impact, including those caused by the exploitation of non-renewable natural resources, the state shall establish the most effective mechanisms to achieve the restoration and shall adopt adequate measures to eliminate or mitigate harmful environmental consequences. So when restoration requires big resources, big money, smart solutions, the government of Ecuador will take it for action, performing this duty against the standards of most effective mechanisms and adequate measures. Article 73, the state shall apply preventive and restrictive measures on activities that might lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles. The introduction of organisms and organic and inorganic material that might definitively alter the nation's genetic assets is forbidden. So you can see by the use of the important words like might and shall in this provision, how wide of a net these provisions in total are casting to protect nature. And in Article 74, persons, communities, peoples, and nations shall have the right to benefit from the environment and the natural wealth, enabling them to enjoy the good way of living. Environmental services shall not be subject to appropriation. Their production, delivery, use, and development shall be regulated by the state. So going back to 71, it had a couple other sentences that I wanted to quickly note about the standing and process issues. It states that all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. To enforce and interpret these rights, the principles set forth in the Constitution shall be observed as appropriate. The state shall give incentives to natural persons and legal entities and to communities to protect nature and to promote respect for all the elements comprising an ecosystem. So as you can see, the rights of nature provisions under Ecuador's constitution empowers everyone to call upon its government and government agencies to enforce the rights set forth in this constitution. Now, the government has a pre-existing duty to engage in environmental protection and regulation of environmental services, but it also shall, under the Constitution, give incentives to others to do the same. Now, our next section will be looking into how these Constitution provisions played out in the following years. And for comparative law purposes, keep in mind how similar or how different these legal frameworks and fact patterns are to those we experience here in the U.S. Starting off with the Vilcabamba River versus the province of Loja in 2011, the question was asked and answered, does a river have a right to its natural course? So in the southern region of the Ecuadorian Loja province, the natural course of a river was not only redirected by the expansion of the Vilcabamba-Quinara Road, but the project also neglected to do an environmental impact assessment. Also, it deposited large amounts of excavated materials and stones right into the riverbed. Interesting note about the Vilcabamba, Vilca means sacred, Bamba means valley, and the place is known as the Valley of Longevity because of its residents' long lifespans, which of course attracts more people, especially retirees, from other regions and countries, which then of course leads to growth issues like adding and widening roads. So the dumping of road debris increased the river's flow, which created risks of disasters and reshaped the course of the river itself. On March 30th, 2011, two residents, Eleanor Huddle and Richard Wheeler, filed for and was granted an injunction against the province of Loja based on Ecuador's rights of nature provisions in its new constitution, specifically Article 71. Ruling in favor of the Vilcabamba River, the provincial court declared that courts must give preference to the undeniable elemental and essential importance of nature, and that it is the responsibility of constitutional judges to incline toward the immediate protection and the legal tutelage of the rights of nature, doing what is necessary to prevent contamination or call for remedy. The court also demanded that the council present the environmental impact study regarding the road and the plan for remediation and rehabilitation of the affected area and riverside population. As of 2012, however, this had yet to be done, but the implementation of the sentence was delegated to the Environmental Department and Loja's ombudsman. The court also held that the government must take corrective actions, such as construction of security bunds to prevent oil spills in the soils around the fuel storage tanks and machinery, clean soils contaminated by fuel spills, implement an adequate roadside system, and store rubbish safely. Final point that is important to note here is that the court stated that the case does not question the widening of the Vilcabamba-Quinara Road, but the respect for the constitutional rights of nature. This is a critical point of clarification, as the court isn't saying that they can't build or widen a road, they just have to do it carefully so as to not violate the rights of the Vilcabamba River. They specifically noted that there was no collision of constitutional rights in this case, i.e. the rights of the citizens versus the rights of nature. They just needed to respect the rights of the river while going on about their business. So from the Vilcabamba case, again, the first ever case to enforce any rights of nature, it held that the actions of the defendant did amount to a clear violation of the right that nature has to be fully respected in its existence and maintenance of its vital cycles, structure, function, and evolutionary processes. This case was also proof of concept that if nature is being harmed by any human activity, such as a river, any individual in Ecuador can file an action in court to try to stop the harm and restore the river. Again, this case did not delve into considerations when rights of people or industry collide with rights of nature. So let's take a look at the next case that arguably does. The Marmesa case involved the revocation of a permit to farm shrimp in a fragile mangrove ecosystem within the ecological reserve of Cayapus Mataji, home to the tallest mangroves in the world. Apparently, they grow up to about 200 feet high. In Ecuador, the Constitution considers mangroves as a fragile ecosystem, which means they must be protected by the Ecuadorian state and preserved by the citizens. The shrimping company did not like that permit revocation, so it filed suit against the Ecuadorian Environmental Ministry, stating that it was an illegal government action. The provincial court ruled in favor of the shrimping company's property rights, and the ministry appealed. On appeal, the Constitutional Court reversed the provincial court's ruling, citing the Constitution as recognizing nature as a subject of rights, and the failure to consider the rights of nature in the lower court decisions. The case was sent back to the lower court for reconsideration. Specifically, the Constitutional Court wrote that it was intentionally forwarding a biocentric vision that prioritizes nature in contrast to the classic anthropocentric conception in which the human being is the center and measure of all things, and where nature was considered a mere provider of resources. It also wrote, this Constitutional Court has been emphatic in highlighting the importance of rights to nature, which result in the obligation of the state and its officials to encourage and promote respect for all the elements that are part of an ecosystem, as well as for nature's right to be respected in her entirety. These aspects have obviously not been observed in a case whose central issue is the installation of a shrimp farm within the Cayapus Mataji Ecological Reserve, a place possessing a system of mangrove with a wide variety of species of fauna and flora. One environmental law attorney out of Ecuador noted that this case represented a, quote, turn of Copernican proportions, as it was the first to recognize nature as a subject to constitutional rights. The legal effects of this case can be summarized in one of the other statements by the court, that all the state's actions, as well as those of individuals, must be done in observance and adherence with the rights of nature. Okay, so skipping back a few years and moving toward the mountains, let's take a look at a 2012 case in Ecuador, the Condor Mirador case. On March 5th, 2012, through its Ministry of Non-Renewable Natural Resources, the state of Ecuador approved a 30-year plus another 30 years in guaranteed renewal, large-scale mining enterprise, the Chinese company to explore and produce copper, chiefly, and gold and silver. The mining project covered close to 15,000 acres, which is about 23.5 square miles, and a pretty good chunk of land. And under the license, the mining project could dig a pit to a depth of 1.25 kilometers or 0.8 of a mile down into that project area. Unfortunately, the mining project known as Mirador went through one of the most biodiverse and fragile ecosystems called the Cordillera del Condor. When local community, indigenous, environmental, and human rights organizations filed for protective action, the local court validated the constitutional rights of nature, but held that the rights were not violated by the license because the mining would not affect an area officially and specifically protected by the Ecuadorian government. Also, the judge stated that civil society's efforts to protect nature constituted a private goal, while the private mining company in this case was acting in favor of a public interest, namely development. So to clarify, the judge is saying environmental protection is a private interest here, while development is a public interest. In ruling that the public interest takes precedence over a private interest, the judge denied the protective action. As you can imagine, the appeal of the decision was based on multiple grounds that the lower court's rejection failed to take into account the petitioner's arguments, constitutional law, or the presented evidence about actual environmental harm and impacts on surrounding communities. But the Provincial Court of Pichincha affirmed the local court decision anyway, and after this loss, no further legal action on this particular case was taken. So, although rights of nature was raised in the cause of action, it was dismissed by the courts before any relevant analysis or discussion took place. So, it's arguable whether it could or should be considered a rights of nature case for the purpose of illustrating the legal doctrine's evolution. It is, however, worth mentioning in the comparative law sense that it represents or presents the reality of other extrajudicial factors that shape lawmaking and legal analysis, namely political power in the name of national, strategic, or economic interests. So the philosophy and ethics of this point is a whole other CLE. Ecuador has seen several more cases that oppose mining in particular for various reasons. Lawsuits have complained of infringements of the rights of nature, the murder of indigenous leaders, the infringement of community housing rights, and the failure to allow indigenous people their right to free and prior consent. Some lawsuits address environmental destruction, constitutional protections against the tailing pond where they hold the toxic mine waste, and engaged in available administrative processes to void existing environmental permits. All such cases and efforts, however, have so far failed. In September 2020, a Cotacachi court granted a constitutional protection action in favor of rights of nature to protect two rare endemic species of frog, as well as monkeys and hundreds of other species whose habitat was threatened by the Yurimagua copper mining project. This project followed a separate decision made by the Provincial Court of Imbabura in another case, upholding the rights of nature of Los Cedros protected forests against mineral extraction. The government of Ecuador appealed both decisions. The hearings have taken place and everyone is waiting with bated breath to hear the Constitutional Court's decision. As you can imagine, the decisional outcome will create a global precedent regarding the balance between constitutional rights of a forest ecosystem and the power of the state and corporations, even foreign corporations, to exploit mineral extracts and reserves for economic development or national strategic interest. So back to 2015, we have a shark finning case. The case actually goes back to 2011 when the Ecuadorian Navy and rangers of the Galapagos Marine Reserve apprehended the industrial longline fishing vessel, the Fair Mary, which was caught 20 nautical miles inside the protected reserve. They also found, when they boarded, 357 sharks on board. In 2015, the Ecuadorian Ninth Tribunal Criminal Court found the captain and crew guilty of poaching sharks in the Galapagos, the first judicial conviction of its kind in the 17 years since the laws were enacted to protect that area. In August of 2015, the captain and crew filed their appeal. When their case was re-examined, the appeal chamber unanimously denied the appeal, confirming the guilty verdict, prison sentences, confiscation of motor launches, and the order to destroy the Fair Mary, which had already occurred by that point. This particular case was included in the lineup because the charges invoked the constitutional rights of nature, namely sharks, to defend them in the reserve. While the conservation sector was not permitted to speak for the sharks in criminal court, they did submit an amicus brief. So in addition to the successful application of the rights of nature in the criminal system, it also raised the question of who can or should represent nature in the court system. While the Constitution in Article 71 stated anyone, the judge in this case only permitted the Galapagos Park prosecutor to try the case. There are several pending cases that are currently pending in Ecuador's constitutional court that could and probably will further shape the legal doctrine of the rights of nature, to include the Piatua River, the Nagaritza River, the Los Cedros Protected Forest I mentioned earlier, and the Dulce Pampa River. So stay tuned for future CLEs to see how all this pans out. These selected cases were only a handful of the rights of nature cases that have been heard and decided on in the state of Ecuador. Just to name a few more to help better understand the shape of things. There were many cases that demonstrated how the rights of nature provisions served as heightened environmental protections, which may have been in addition to pre-existing laws in Ecuador. For example, when a community decided to cut down nearly 450 acres of native forest to establish a palm plantation, they were shocked to find out that they needed permission first from the Ministry of Environment, so they were fined $375,000 to pay to restore the logged area. The action was justified by citing violations of the constitutional rights of nature provisions and the forest law, which was originally enacted in 1958. Same year in 2011, the Ministry of Interior asked the 22nd Criminal Court of Pichincha to authorize the ministry to take extraordinary precautionary measures to combat unauthorized mining in various areas, arguing such activities violate the rights of nature provisions in the Constitution, particularly the rights of water. The court approved the request and ordered the armed forces and other government agencies to conduct operations to control illegal mining to uphold the rights of nature. Such operations were carried out on May 21st, 2011, where nearly 600 soldiers seized and destroyed more than 200 pieces of heavy mining equipment. Similar operations were conducted in the following years. When we look at cases with application to certain species, one criminal lawsuit cited the rights of nature provisions in the Constitution when it prosecuted a hunter for shooting down an Andean condor named Felipe, who, come to find out, was injured and rehabilitated the year before. The suit argued that since Andean condors are in danger of extinction, killing one threatens their right to exist. The defendant was convicted, but the court reduced the 1-year mandatory sentencing to 6 months in prison because he was a senior. He was 61 years old. Similarly, a Facebook photo in 2012 showed several people posing with a dead jaguar, which was reported to the Ministry of Environment. The investigation determined that a man named Luis Bondo killed the jaguar, and in 2014, criminal charges were filed for crime against nature. He was convicted, sentenced to 10 days in prison, and ordered to pay damages to the ministry. He appealed. The provincial court rejected the appeal and, due to aggravating circumstances, increased the sentence to 6 months in prison. When Obando appealed that, it was rejected by the National Court of Justice, which upheld the six-month sentence. And finally, while this case reaches back to 2009, it is a case with an interesting feature. Actually, the biodigester case stems to 2003, before the constitutional rights of nature provisions came into place, to a time when the citizens of a community complained to the national government about water air, and soil contamination produced by a large-scale pork processing plant owned by the agro-industrial company Pronaca. After governmental administrative actions failed to solve the problem, the claimants filed a lawsuit in 2009 for protective action requesting a stoppage of 6 new biodigester machines that Pronaca was installing to process the methane gas released by intensive pig farming. While the lawsuit noted the negative impacts on the flora and fauna, it did not invoke the rights of nature specifically. Rather, they focused on their own constitutional rights to health and a safe and clean environment. The Constitutional Court ruled against the claimants' proposed protections and stoppage of the biodigesters. However, the judge also ruled that the case involved potential violations of the rights of nature that needed to be protected. So here, the judge decided that the claimants' human constitutional rights to health and a safe and clean environment were not apparently violated here. However, nature's rights may have been. Invoking Articles 71 and 72 of the Constitution, the judge ordered the creation of a commission to audit and monitor the biodigesters, water usage, and waste management to ensure that the rights of nature, citizens, and communities would be protected. So as you can observe, the ruling of this case is significant in that the court acknowledged its own right to invoke constitutional articles regarding the rights of nature, even if and when the claimants did not specifically do so. So zooming out and looking at the big picture development of rights of nature in Ecuador, it may seem like it's been all over the place, but there have been many important strides in the development of the doctrine. It's indisputable that much has happened in the last 13 years. A turn of Copernican proportions has happened, where the state of Ecuador declared in no uncertain terms that nature is the subject of rights, that people can have standing to sue and enforce such rights without having to first prove damages to themselves, that all levels of government have a clear duty to protect the rights of nature as do the people, that sometimes there are hiccups in the evolution of legal doctrine, such as court orders not being followed or courts not addressing rights of nature causes of action or the underlying evidence in the face of purported national interests. But in the end, the constitutional rights of nature provisions have been invoked and used in both civil and criminal courts, administrative investigations, and accountability processes, and even executive actions, such as military operations in defense of nature's rights. So you can see how and why Ecuador is a hotbed of jurisprudence as it pertains to the global movement for the rights of nature, and why the world is watching what the Constitutional Court does next. So let's take a look at a few more countries and how they approached and treated the issue of recognizing and enforcing nature's rights, specifically India, Colombia, and Bangladesh. First up is India. Over the past 4 years, courts in India have, without constitutional amendments or legislative enactments, come out with several orders declaring rivers, members of the animal kingdom, and lakes as entities granting them certain rights equivalent to a living person. In 2017, it started off with the Ganga and Yamuna rivers, including the Gangotri and Yamunotri glaciers and other ecosystems as legal persons with certain rights. In 2018, the same court extended rights to the entire animal kingdom. And in 2019, a different high court also recognized that all animals are legal persons, and in 2020 added the declaration of legal personhood to the Sukna Lake with rights to survival, preservation, and conservation. These orders may not have the procedural mechanisms needed to be able to affect or stop the destruction or exploitation of these natural entities, but advocates have noted that they've been beneficial. They've served to transform the legislative approach to nature and how developmental projects are managed. Some commentaries on the effects of these judicial orders have emphasized the beneficial creation of dialogue and opportunities to better understand the transboundary rivers, and the need to collaborate with neighboring countries on ecological grounds. Others have used the opportunity to propose better ways to accomplish the same or similar objectives, such as appointing guardians or designating the National Green Tribunal, High Courts, and Supreme Court of India as counterbalancing forces in a political and institutional environment where non-compliance is rampant. Overall, the clear effect of these judicial orders is a continuing signal for the growing discussion and international trend of granting rights to nature. In 2016, the Colombia Constitutional Court, again without precedent in Colombian law, recognized the Rio Atrato, or the Atrato River, as a subject of rights. This jurisprudential milestone occurred with the backdrop of regulations continuing to fail to protect biodiversity and related rights of the inhabitants of the areas near the Atrato River. In 2018, the Supreme Court of Colombia held that the Colombian Amazon was entitled to be included in the same category. Same year, the Administrative Court of Boyacá recognized the Páramo de Pisba, which is an Andean ecosystem, as an entity subject of rights in its judicial sentence. From this, you can see how the high courts of Colombia have illustrated a collective consideration about the protection of certain rights conferred to all and that have an interest to all people. In these decisions, it appears that the recognition of the rights of nature is based on what the courts believe to be an ethic of survival of generations to come. In a few lower courts as well, the single civil municipal court of La Plata, Huila, recognized the Plata River as the subject of rights. And the Fourth Court of Penalties and Security Measures in Pereira recognized the Otun River as a subject of rights. Other court rulings in Colombia include the Regional Court of the Province of Tolima. In 2019, it recognized the rights of the Coello, Combeima, and Cocora rivers as a subject to rights of protection, conservation, maintenance, and restoration. The Superior Court of Medellin in 2019 recognized the Cauca River as a subject of legal rights, and the Quindío Administrative Court in 2019 recognized the Quindío River as a subject to rights. Supreme Court of Justice 2020 recognized the Isla de Salamanca Park in the Caribbean as a subject of rights. And finally, the Supreme Court in 2020 recognized a national park, La Bien Parque Isla Salama, as a subject of rights. So let's look now at Bangladesh, known to many as the land of rivers because it literally has hundreds of them, and they all have been getting more and more polluted. In 2019, the Supreme Court of Bangladesh recognized the legal rights of all those rivers within the country. The court declared, "Water is certainly the most pressing environmental subject of the next century," and called for waterways to be protected whatever the price. Now, people who cause damage, or entities who cause damage to any river in Bangladesh, can get taken to court by the government-appointed National River Conservation Commission and tried as if they harmed a living entity. The river's government-designated human representatives can sue on its behalf when it's in danger. In other legislation, in 2010, and these are more on the municipal level of things, but in 2010, Bolivia had passed a law of the rights of Mother Earth, and that was about a year after Bolivia's constitution reoriented toward, as scholars have noted, respect and equality and the search for well-being and collective coexistence, with access to water, work, education, health, and property. The protection of the environment was implemented into a crucial component of the Bolivian Constitution, and in its Article 33, states that the government has the obligation to guarantee the responsible and planned use of natural resources in order to promote, among other things, the well-being of present and future generations. The law of rights of Mother Earth gives nature legal rights to life and regeneration, biodiversity, water, clean air, balance, and restoration, and mandates a fundamental ecological reorientation of Bolivia's economy and society, requiring all future laws to adapt to Mother Earth law and accept the ecological limits set by nature. Practically, the law requires the government to transition from non-renewable to renewable energy, to develop new economic indicators that account for ecological impact of all economic activity, to carry out ecological audits of all private and state companies, to regulate and reduce greenhouse gas emissions, to develop policies of food and renewable energy sovereignty, to research and invest resources in energy efficiency, ecological practices, and organic agriculture, and to require all companies and individuals to be accountable for environmental contamination with a duty to restore damaged environments. Bolivia created a new Ministry of Mother Earth, an Inter-Ministry Advisory Council, and an ombudsman. Despite these legal provisions providing infrastructure for transition, however, the effectiveness of such laws have yet to play out against the reality of an extraction-based economy in Bolivia. Starting in 2014, New Zealand has taken a more enforceable and direct approach than incorporating rights of nature in its constitution by directly and explicitly recognizing the Te Urewera National Park, the Wanganui River, and Mount Taranaki as legal entities with rights, powers, duties, and liabilities as a legal person. Embracing traditional indigenous knowledge of the Maori people with the modern legal system, New Zealand became one of the first countries in the world to give a mountain, river, and national park legal personhood status. In Brazil, municipal laws recognizing rights of nature have been approved in the state of Pernambuco, where the cities of Bonito and Paudalho both recognize such rights in 2017 and 2018, respectively. Bonito amended its municipal law with Article 236, which states the municipality recognizes the right of nature to exist, thrive, and evolve, and should act in order to assure all members of the natural community, human and non-human, of the municipality of Bonito, the right to an ecologically healthy and balanced environment and to the maintenance of ecosystemic processes necessary to good quality of life, being the public power as well as the collectivity in charge of defending and preserving it for the present and future generations of the members of the Earth community. It goes on to say, in order to ensure this right, the municipality shall promote the amplification of its public policies in environmental, health, educational, and economic areas so as to provide conditions for the establishment of a life in harmony with nature. And it shall articulate with other state, regional, and federal competent bodies, as well as other municipalities, if it is the case, in order to solve common problems related to the protection of nature. So if we continue spinning the globe, we'll see many other places in the last few years continuing the growing trend of establishing rights of nature doctrine. In Uganda, its National Environment Act specifically includes the rights of nature. Another municipality of Brazil enacted a law recognized the rights of nature. The state of Colima, Mexico, recognized the rights of nature in its state constitution. And in New South Wales, Australia, the Blue Mountains Council adopted a measure integrating the rights of nature into its municipal planning and operations. And in Canada, we have a tribal council and a municipality both adopting rights of nature laws to protect the Magpie River. As we are still in the infancy phase of the rights of nature movement, it is important to note how and why different countries have enacted and implemented the elemental standards into their own systems. In some places, legal developments are opportunities for citizens and institutions to learn, debate, and implement heightened legal protections for the sake of nature. In other places, it is the sake of nature itself that creates the cause of action and legal standing with clear, proven constitutional and judicial backing. However rights of nature tenets are implemented, it is clear that citizens across the globe have recognized the failure of the regulatory system and have chosen to do something more to actually conserve and protect nature and natural systems. The question becomes, of course, can we do that here? So, all right, so the next section